So, when you purchase your own home, as a married couple or a civil partnership, your solicitor will normally take the default position and make you joint tenants. So your property, where you live, will be owned as joint tenants. Now that's fine, but as you get older, there may be some issues that you have as a family that may affect your children inheriting the property. So we're going to look at these later. As you can see, as joint tenants, you own your own home equally, and when one person dies, the ownership of the house passes automatically to your surviving partner. So as you can see now, the remaining spouse owns 100% of the property on the first death. As long as the remaining spouse lives a healthy, normal life and does not remarry, the children will inherit the house when they eventually pass away. But life's never that easy, is it? So let's look at one of the first threats that may come up in your family, which is remarriage. If the remaining spouse gets remarried or enters a new civil partnership, then the new couple will now equally own 100% of the house. So now, living together as a new couple, married or civil partnership, you'll probably want to write new wills because your old ones will become invalidated on your new marriage or your new civil partnership. And you may decide between you as a new couple that you're going to leave your assets to your children and they're going to leave their assets to their children. But what happens if you pass away first and your new partner, your new spouse, rewrites their wills, gifting all your assets to their own children? This is effectively what's called sideways disinheritance, where your children are disinherited sideways to your new spouse's family. Now let's talk about divorce. If you own 100% of your house and you get married and then unfortunately get divorced, all the equity is at stake for your divorce separation, which may mean that some of your assets are passed to your now ex-spouse through a divorce hearing. So let's hope that you live a nice healthy life, you have no issues, you don't get remarried, and you just pass away in normal circumstances. Your children don't inherit your house the day after you've passed away. Unfortunately, you have to wait for the probate process, which is the tax man waiting to see if there's any inheritance tax for you. This can take up to 6 or 9 months before the house is effectively put into the children's hands. And if the children are using a solicitor at this stage, a solicitor will generally charge the children around 2% of the value of your assets. So a couple of £100,000, you're looking at £4,000 to £5,000 worth of solicitor's fees. So at the time of your death, hopefully you've got a valid and up-to-date will with all your expression of wishes in it to make sure that everyone in the family is getting their equal share, or however you're dividing the estate up. But if you haven't left a valid will, or unfortunately the children can't find it, you don't go through the probate process. Your estate goes through the letters of administration process. And at that stage, it's not you dictating who gets what from your estate. It's down to the laws of the land to do that. So please make sure you've got an effective and valid up-to-date will. So now we've got to the situation where your estate's come through probate process, and it may be your children or your family who are deciding now, according to your will, where these assets are going. It's at this stage, if your family below you have got any issues around divorce for themselves, maybe they're becoming insolvent or being chased through bankruptcy through the courts, maybe they're currently living on disability benefits, or they've got relationship problems themselves. They wouldn't necessarily want to inherit money from your estate right now until they can sort their own problems out. So now we're going to look at some effective estate planning tips around issues around for your children. So the first stage in estate planning that we've got in our toolbox is to become tenants in common. This is where you're effectively severing the equity in your property and becoming owners in your own right. Effectively, what you've now done is become 50% shareholders in your own home. Other percentages can be set up, so if say one party puts more money into the property at the beginning, they can have a bigger share. So now we become tenants in common. Let's go back to the first threat that we made earlier on, which was your remarriage after your first spouse's death. As you can see, as the equity has now been split, so your new partner can only ever be entitled to your half after your death. Your first spouse or partner share stays in trust for your blood family and will pass to them on your death. This also applies to a divorce. As you had never effectively owned your late partner's half of the house, only your half of the house can form part of your estate on your divorce. But severing the equity in your property does not really ensure that your children get the maximum inheritance that they're due if they've got some of the issues we talked about before around divorce and disability, breakups, issues with drink and drugs, or maybe they're being chased for debt or they're just about to go bankrupt. So now let's look at some effective estate planning which takes into account probate, the cost and the delay, and all those other threats that your children and your bloodline family may face after your death. Now we're talking about lifetime family trusts. Setting up a trust during your lifetime is what's known as a restricted practice. That means that in the UK, only a solicitor or barrister can set those trusts up for you. And we use various companies around the UK to help with our clients' needs, depending on the client's circumstances. What is a trust? Well, it's a legal entity that can hold assets, normally a family home, but it can also hold other things too. It needs people who are in charge of what happens to those assets, and they're called trustees. The trust will also have beneficiaries, who are the people that benefit during your lifetime, and those who benefit when you're gone. As the homeowners, you are normally all three of these, as you will still need to live in your home whilst you're alive and benefit from it too. We will set up a trust designed for your specific family circumstances, but we'll cover off other different types of trusts in a different video. Now we've got your trust set up. Now we have to get the solicitor to convey your title deed on your family home at the moment into your family trust. So, your house is now in your trust. Nothing's changed, you still live in the house, you can extend it, you can actually move, you can move home, and your trust just buys your new property. So as far as you're concerned as a client, nothing's actually changed. Let's talk about remarriage then. So, your house is in trust and your first spouse has passed away and you've now remarried. If that relationship doesn't work out and you're going to get divorced, the house that you live in can't be used as part of your divorce case because you don't physically own it. It's owned by your family trust. This will help with sideways disinheritance, so that your family aren't disinherited sideways to your new spouse on divorce, or if you were unfortunate enough to pass away, then your remaining spouse can't inherit that asset because it didn't belong to you. It's only going to pass to your bloodline family. The other great thing about having your house in trust or other assets in trust is that anything on your death that's inside a trust avoids the probate process altogether. As its own legal entity, it doesn't need to go through the probate system. Probate deals with an individual's estate on their death, anything over £5,000. So if you died on the Monday, in theory, your children would inherit the assets on the Tuesday and could start to sell assets, cash in bank accounts that are inside the trust, effectively reducing the cost and fees for probate and also the legal costs for your solicitor to do that process for you. So let's look at issues that your children might have with the house in trust and your assets in trust when you eventually pass away. We talked about these earlier. Maybe your children are in a situation where they're just about to get divorced, or maybe they're unfortunately living off disability benefits. Perhaps they've got debts and they're being chased by a creditor or a debtor. Maybe they've got issues with drink or drugs or something like that. Effectively, this is where the trust comes into its own. As the trust currently holds all your assets now you've passed away, if your children find themselves in any of these situations, then the trustees at the time of your death will hold all the assets inside the trust until your children have sorted their family situation out. Maybe they need to get divorced or sort out their debt problems, maybe they need to go insolvent and go through the bankruptcy process. And after that, when they've sorted all their family circumstances out, they can come back and claim their inheritance from the trust. Living on disability benefits, if that's what one of your children or a member of your family that are going to benefit from your will were in that situation, if they own more than £16,000 worth of assets currently, then their benefits will stop. If you've left them inside your trust, then their benefits will continue to be paid. However, the trustees can pass those, your children, pieces of the capital as and when they need them. That doesn't affect their entitlement to benefits. Again, another really great reason why you'd use a trust. These things have been around since the 13th century, they're nothing new, they're cost effective, and what they will give you is really good peace of mind that you know whatever your family circumstances, either before or after both of your deaths, that your family are going to inherit the things that you want them to do in a timely manner, no matter what issues they've got. Probate's been completely avoided, so there's no delays from your family picking up these assets. Alongside the trust, you should also have valid and up-to-date wills that match your needs for your family, and these will change, and we regularly review these each year with our clients. And the two most important documents that sit alongside these estate planning documents is lasting powers of attorney. One for health and welfare and one for property and affairs, and we'll deal with that in the next video.